live. This is Law Call.
Good evening. My name is Ted Howell with the law firm of Perry & Young, and we're here for an episode on wills, estates, and trusts. The phone lines are open this evening at 850-392-1544, and you can reach us at email at lawcall@wmbb.com. Before I introduce my fabulous guest for the evening, we'll go to an opening email question that we had before the show. We were broadsided by a lady who admitted to running a stop sign on a rural road. We exchanged contact info, but she told us she doesn't have any insurance and will just pay us out of pocket. What legal rights do we have? And that's from Greg. Greg, this is a very good question, and actually a situation that arose at the office this week. What do you do when someone says they don't have insurance, or even maybe suggests that you don't need to call the police? Well, first and foremost, anytime you have an accident, make sure you call and have it documented. Document, document, document. I can't emphasize that enough, because not only do we have to look at the potential claim that you have against this person, which can proceed whether or not they have insurance, but you also potentially have rights under your own policy, not only for the property damage, but also for any injuries that you have that you might have incurred. And that would be on your policy with your company, which has certain rights and obligations that you have to take care of. One of those are that you actually document that you've been in an accident in most policies. So please never leave the scene without making sure you get that documented, even if the person suggests that it's not necessary because they don't have insurance or for any other myriad of reasons that they could do that. So please do that so that you can make sure and pursue any and all claims that you have on your own policy. With respect to the individual that caused the accident, if they did not have insurance, that does not mean that they do not have exposure or liability. It just means that they may not have assets that you can go after. So we have to do an analysis for you to see if that's someone that we can pursue. You definitely have a claim. The bigger question is there something that you can recover at the end of the day? So make sure and give us a call, Greg, so that we can look at all of those options, both on your policy and with respect to the person that caused the accident. Because even if they don't have insurance or assets, there may be someone else that does have coverage for them. So it's just important that we look at all of those avenues for you so that we can make sure and get you through this process as quickly and efficiently as possible. Thank you for that. And that was a personal injury question. But tonight we're going to be focusing more on the probate world, the estates, the trusts, the wills, and I have with me an expert in that arena, Mr. Chad Templeton. How you doing, Chad?
I'm doing well, Ted. How about yourself?
You know, I can't complain.
Absolutely.
For middle of June, I guess we're close to 3rd of June, whatever.
It's warm June.
Exactly. Chad, I know you've been on the show many times. Why don't you go ahead and just give a little bit on your background?
Yes, sir. So my name's Chad Templeton. I'm a probate and estate planning attorney here in Panama City. I do everything from wills, trusts, powers of attorney, probate. Ideally, we deal in probate avoidance. That's the first part of my job is probate avoidance. But you know, sometimes things fall through the cracks. We have to know probate proceedings for folks, and we take care of that as well. Okay.
You know, one question that actually came through the office this week, Chad, that I think is really important. That many people don't understand, and somebody called us up and said, you know, Mama didn't have a will, but she absolutely gave me a power of attorney, and you know, brother's not wanting me to do this, that, and another, and I told him I had this power of attorney, and I'm going to take care of all of this. Well, Chad, when someone has passed away, does that power of attorney give them any legal rights anymore?
Yeah, unfortunately not. You know, when you have a power of attorney and you pass away, that power of attorney passes away with you. And that's why we have court processes that appoint things such as personal representatives or executors is what Florida actually likes to call those positions. But yeah, if you have a POA, a power of attorney, it's important to know that when you pass away, that power goes with you. And therefore, you know, we need to have other documents in place that's going to basically dictate who will step in and make decisions after your passing.
And on that too, there's another one, that the distinction between a durable power of attorney and just a traditional power of attorney. What does that durable mean, and how does that have any additional legal significance?
Yeah, so you know, the durable means it survives an incapacity. If you create a document like a power of attorney and you become incapacitated from something like Alzheimer's, dementia, maybe even a traumatic brain injury, without that language that makes it durable, that power of attorney is not valid upon your incapacitation. It's always important, if you do create a power of attorney, make sure you have that language that.
And there's some language in the statute that requires that you have.
Absolutely, it has to. You want to make sure it spells out, it survives your incapacitation.
Because absent that power of attorney that has that durable aspect, if you don't have that and you get into a situation where somebody's incapacitated, that requires you to go through a guardianship process, which requires medical professionals to come and have your loved one declared incompetent, and then to have court oversight over what is being done, and it gets the court really involved in your life.
It's expensive,
right?
I mean, if you just seek out an attorney, they're going to prepare a durable power of attorney for you. They're not going to just prepare a regular power of attorney. Now, the dangers with that is, though, if you find a form online, you might not be, you might not have that durable language, and therefore something happens, you could be in a bad spot.
And that's one of those real big dangers where we see a lot of these different companies that have these forms online, and they may be from a different state that maybe doesn't have quite the requirements that we have in Florida. And you go on there and it seems real easy and it seems to make sense, but you miss something like that durable language.
Absolutely.
And then same thing can happen with wills. There's requirements and formalities that you need to have, and things have to be documented properly. So it's important that you seek out someone like Chad anytime you're trying to create those documents.
Yeah.
Because not only do you have issues in the arena of powers of attorney, but when you're dealing with healthcare providers and making medical decisions, what kind of documents do people need in order to navigate those issues when they're dealing with loved ones that are entering into those phases?
Yeah, so I mean, we have something called a healthcare surrogate, which is like your healthcare power of attorney. Think about a durable power of attorney as strictly legal and financial decisions, and then your healthcare surrogate covers all those healthcare related decisions, usually excluding the end of life decision. There's a separate document out there called a living will that takes the burden off of loved ones to have to make those hard calls. But a healthcare surrogate is effectively a document that appoints somebody to say, hey, if I can't speak for myself in a medical setting, if I can't collect my medical documentation, this is the person I trust to make those decisions for me.
And I can tell you, having been through some of these issues recently with a loved one, it's important to have those things in place beforehand, because you're not wanting to have to scramble and do that with someone on there in a hospital bed, and it's just not a good situation. You can do it if you have to, but it's not ideal, and those professionals will ask for those documents, and you need to have them handy, have copies, have them scanned as well, so that you can use them when needed. And that's very important.
And I will say, Ted, a lot of my clients come in and they say, well, we're married, so I should be able to make all the decisions for my spouse. And unfortunately, that's just not how it works. I mean, without that designation, without that document, you may be in a situation where you're having to go through guardianship to make legal, financial, and/or healthcare decisions for your loved ones.
Which is the last thing you want to be doing when you're trying to focus on helping your loved one go through a difficult physical time.
That's right.
You mentioned something at the opening, Chad, about probate avoidance.
Yes.
What kind of things are we talking about there to try to set up your estates and your assets to avoid things like probate if possible?
Well, the very first thing that everybody who is listening tonight should do is go check your bank accounts, or really any financial account for that matter, whether it's retirement, life insurance. Make sure you designate a beneficiary on that account, and then make sure you designate a contingent in case that primary, heaven forbid, predeceases you. You've got a backup already named who will be taking that money. And that simple act of designating a beneficiary is what keeps that money out of the probate court system and goes right to that individual.
Well, Chad, one thing that actually came to my attention this week, and I've dealt with this in a past life before, but designations, you just made that mention. Some things that don't get sometimes caught in divorces are designations where people have been designated as beneficiaries, whether it's in a will or a life insurance policy or a bank account. Does Florida have any statutes that deal with that if someone has been divorced and they haven't made an appropriate designation on how those are going to be treated post-divorce?
So that is a good question, and unfortunately Florida has thought about that. And they say, if you have designated a spouse in your will and then you get a divorce, Florida law is going to treat that spouse as having predeceased you. And therefore, if that will has to go through probate, whoever is the backup beneficiary will be that primary taker.
Okay, we got a phone call on the line. If you would put that through, please. Chris, you're on the air. Please go ahead with your question.
Yes, sir. How you doing? My question is my mother passed away a couple years ago, and she had her husband as the beneficiary, but he passed before she did, and she didn't change the paperwork, and she has 3 boys that's left over to finish out all the paperwork or what have you. And from what I understand, it's something about we got to go through probate court, or how we file that.
Good question, Chris. The husband predeceased, so I mean that's one of those things where you have to live in order to get the benefit of those designations.
That's right. That's right. And that is a unique situation that doesn't come up very often. But I actually have had this situation occur before, where there was a trust. The only named beneficiary in that trust dies before the trust maker, and then the trust maker dies. Well, then what happens? Well, Florida law basically has to come in and say, we presume this person died without a will because there's nobody else named in there. So in that situation, more than likely a probate will be required, because the probate court's going to have to outline who the intended beneficiaries are, and the Florida statutes will come in play and dictate who those heirs are.
And typically do it through the normal intestate structure.
That's correct.
So that's why it's important to do successor beneficiary, so that you can get your wishes if something like this happens. We're going to take our first break of the night. Those phone lines will still be open, or you can email us at lawcall@wmbb.com. We'll be back shortly. Welcome back to Law Call. Ted Howell with the Perry & Young Law Firm, along with Chad Templeton. We're taking your calls at 850-392-1544. And during the break, we got a call from Kyle. Kyle, proceed with your call, please.
I was just going to ask, how long do you have to contest a will, and would the person misspelling their own signature be grounds for, the will being signed under duress? So if the deceased has been diagnosed with dementia and, Alzheimer's.
I got you. Well, Kyle, I assume this may be in Houston County, so I don't know particularly. I know you're practicing in Florida.
Yeah, I'm licensed in Florida.
But as a general rule, I know there's time periods depending on once the will's been filed.
That's correct. And really, there's also not only once the will has been filed, but once you are served with particular
notice
pleadings through the probate system, that triggers some type of statutory deadline to contest it.
Right, but you mentioned something there. Kyle, about the dementia aspect. That's a bigger issue than the signature. I mean, the signature spelling could be an indicia of it, but the issue there would be if we could possibly show or establish something about your state of mind, because that's one of those more important things that you got to be able to make sure and take care of on those.
Yeah, you need to have full capacity to be able to enter into a last will and testament. And really what's tough about challenging capacity is when the individual who made the will has passed on, you're kind of left doing some detective work in retrospect. You're interviewing the medical professionals, the people close to that individual, and it's tough to challenge that. And that's also why it's important when we do these wills, we have these witnesses and notaries who are present, who could serve as fact witnesses, not the only witnesses.
Right, I've been through those kind of processes before, and you can get into an in-depth medical analysis and then close in time and when those things have been diagnosed, and the general practitioner can become very important, loved ones can become important. In Florida, you can really have a lot of factors with respect to undue influence, which are also applicable in Alabama. So, Kyle, make sure and reach out to us, and we'll help you get in touch with somebody that can help you with that special issue.
Now, Ted, I will say too, just because a person has dementia doesn't mean that they can't enter into a will or a power of attorney. Dementia is it's a spectrum, and as we age and the dementia becomes more severe, obviously the lack of capacity increases, and so just because somebody has dementia doesn't mean they can't create a will, but that is a factor if you are looking to challenge the admittance of a will.
I got you. I think we got another call on the line. I believe it's a John from Jackson County. John, go ahead.
I have my bank account with joint ownership on the bank account. How do I get the title to the land where it will be joint ownership? Can I just go in and ask that it be put on, or have I got to get an attorney to fill it out, or what?
Very good question. So she's already gotten the bank accounts, as you've suggested. Now, with respect to the land, real estate. Is that something you can pull off a form off of the internet, or is that something you likely need an attorney to help you with?
Well, the short answer, of course, Ted, is I'm sure there's a form out there on the internet, but you want to consult with an attorney because they're going to give you pros and cons as to which deeds you should and should not do to add anybody to your property.
And it's so easy to mess up a deed or not record it properly, because the clerk of court will more or less accept what you give them, and they're not there to help you or practice law. I mean, they're a repository. And so that's not something you want to, go cheap on and not make. You want your land to go the way you want it to go.
That's right.
And there's, like you said, there's a couple of different options that may have different tax implications. They may have different legal implications. So you want to make sure you get that right. And so that's something you can do relatively modestly.
Absolutely.
But it's something you want to have done properly, because in the long run, you're going to end up saving your family a whole lot of money by doing one of those probate avoidance things that you've suggested, as opposed to having to go through a full-fledged probate. While we were on the phone, the producers sent me a message. There was someone that had called in, but I think couldn't stay on the line, and it was asking, they said about a ladybird will, but I think they meant a ladybird deed. And I know that's something, Chad, that you've discussed on here before, and is a very popular thing to do. And could you explain what that provides and what that does for you?
So a ladybird deed is effectively a transfer on death deed. You create a deed that states, hey, I own this property for the rest of my life, and when I pass, it automatically goes to whoever you've designated in that deed. The wonderful thing about that deed is you still own it, and if you want to sell it, nobody can stop you.
Right.
If you want to give it to somebody else, nobody can stop you. There's really no taxable consequences with that either, because nothing is changing hands until you pass. Obviously, there may be some capital gains down the road, but as far as you keep your step up and basis intact. So while we're alive, we don't want to gift property. That's sometimes it creates a domino effect that we didn't intend. So a ladybird deed is something that I preach about every day in my practice. If you have adult beneficiaries and you have real property, well, a ladybird deed is probably going to be the way to go for your situation.
And especially if it's not an investment property that you're planning on selling anytime soon. This is something that you're planning on holding on and leaving to the family. That's another one of those avoidance things that can save your family a lot of money at the end of the road, but still leaves you the flexibility to be able to do with that property. So that's, Joan, that's an example of a thing that a lawyer could tell you when you go in and speak with them, to give you that option. Is something that may be the best for you. But you're doing the right things by doing the bank accounts, the financial things, because everything you do, because otherwise, if you don't have those kind of things set up, the things that you're talking about happen essentially automatically upon the death. Otherwise, you're having to wait, open an estate, publish notice to creditors, do all of these different things that require a delay before your family members and loved ones have full access to certain assets and property.
Just from the cost of loan standpoint as well, I mean, you're talking about a deed, a few $100. Well, you know, if you have to go through probate for that same piece of property, you're talking about a few $1,000s. And so, I mean, 1/10 of the cost. If you have any questions about whether you should do a ladybird deed or any other type of deed, please consult with an attorney, because there are some benefits out there to take advantage of.
And another just general basic thing that is not necessarily even legal advice, but make sure you have all of these papers, passwords, all of these different things in a place that some loved one knows where they can find them. So because it can be very difficult just to get into someone's iPhone if you don't have those passwords.
Absolutely.
And so many financial accounts and different things are done electronically now. So make sure you have this information stored in a safe place for safekeeping, that your loved ones know where it is so they have access to that.
I recently had to do a probate Ted, that the individual had a safe deposit box, and they didn't put nobody else's name on the safe deposit box. So when the person passed away, we had to go through probate, spend a little bit more time than anticipated just to get in this box, and the box was empty. So,
well, I was going to say, so many people don't even, I mean, that was things that my grandparents, everybody had safety deposit box. And a lot of people still do that, and there's nothing wrong with that, but it's not done as frequently. So if you have something like that, it's extremely important.
That's right.
That you let people know, and you have other people on that account with you so that they have access to it.
You had mentioned something earlier, too, about an investment property, you know, saying, well, if we're not talking about investment properties, maybe this deed will be appropriate. That kind of brings another topic to mind when we're talking about investments. You know, you can do estate planning for yourself personally, but you can also do estate planning for your business interests as well. You know, it's always wise to make sure if you do have an investment property, you want to limit that liability if you can through an LLC or some type of corporation. And then it's important to note you can have an estate plan for your business, such as an operating agreement that spells out, you know.
Absolutely. That's very, very good point. Well, we're going to take another break now, but remember those phone lines are open, 850-392-1544. Welcome back, and while we're on the break, I actually checked the LawCall live feed and saw that our former fabulous host, Kelly Grossfield, now Kelly Goetz, who just got recently married. I hope I didn't butcher your name, Kelly. I'm sorry if I did. But Kelly, like I said, just got recently married and wanted to know, Chad, when in that time period is it appropriate for her to get a will?
I mean, if you have to ask, probably, now. Why not?
Right.
I mean, what's the holdback? It's pretty simple. We can create these documents as a snapshot in our life now, but as life changes, we can always update them. So might as well go ahead and put something in place just to ensure your loved ones are protected.
It's better to be safe than sorry. Like you said, you can always update it. You can go ahead and plan for some of those contingencies, some of those life expectancy things that you plan on doing and things of that nature. So always good to be safe versus sorry and have that in place. But once again, congratulations, Kelly. We do miss you. We wish you had you here tonight. It would have helped bring a little character to this.
That's right.
It would make us look a little better.
That's right. Absolutely.
But we're going to power through this. We've had a good time talking about estates trust. Great having you again, Chad. What kind of shout outs you got tonight?
Well, obviously you want to wish shout out to my lovely wife Amber and my daughter Amelia. I hope they're in bed. I know she was fighting it tonight, so hopefully they don't see this. Shout out to my parents, my grandparents. Also, shout out to the Florida Gators baseball team today.
They about gave me 3 heart attacks, but they pulled it off.
Two College World Series, 2 years in a row. Can't be happier with that.
No, that's a very good effort today. Well, I need to give shout outs to both of my kids who I believe stayed up since they're on summer. I allowed them to stay up. I didn't allow them, they're staying up. Also, my beautiful wife traveled over to Pensacola this morning all by herself, 3 hours or 2, however long it is there and back, and taught a class and did. I've already got extremely good reports about her, so I know that she did an excellent job. I'm so proud of you, Heather. Shout out to my niece, Brooke, who loves to watch LawCall. Shout out to my dad over in Mexico Beach. Shout out to Larry, the Godfather Perry, who's at home watching. We'll get him back here on the show before you know it. We just thank you all for coming in here. Make sure and be safe. There's a lot of crazies going out there. I don't know if you saw about that crazy boating accident out there. There's a lot of folks in town that aren't used to driving around, so be extra safe out there. And we will be back next week with another personal injury show.